Good morning.
Good morning.
Good morning. I'm glad somebody's listening to me. Good morning, Mr. Williams.
Good morning. Good morning.
Who's here for the other party?
My understanding is that it's only going to be me and Mr. Williams. We don't anticipate appearance by the municipality.
Is that so? They filed ahead.
Unless if I'm wrong, Mr. Williams.
First of all, Mr. Kiro, who do you represent?
The SIU.
But you're a student.
Pardon?
It's written there, student. Do you have right of appearance?
No, it shouldn't appear like that. I'm an advocate. I apologize for that.
I was a bit worried.
Okay.
Going to ask you to show me a certificate.
Yes.
Okay, so all right. Then it's fine. Because that's why I was confused.
Oh, okay.
Yeah, that's right. All right, Mr. Williams.
So, yes, my lady, I appear for the.
Okay.
Now there was an order made. I think your ladyship made the order.
Yeah.
In that interlocutory, where we try to solve the problem by ordering the Madibeng local municipality to give us the full record of the decision, and they haven't complied with that. We don't have anything from them.
Mr. Williams, I'm in a bit of a dilemma, and I'm not sure how to approach this whole application. And I'll tell you why. That since this your application, I've had a decision by Modiba J in the LNG matter, which is, I think, of course, all falls on this, so similar to this matter, and I'm bound by it to the extent that I agree with it. And right now, I have to agree with it because there isn't any other.
Yes, but we would argue that as to the dilemma, my lady, we would argue that you are functus officio and that we made your order and they're not complying with it, and that's why we want to look at the other prayers as well, where the municipal manager and they must bring it. They're trying to set aside a decision. The notice of motion, even in the amended notice of motion, in the original and the amended notice of motion, The relief is very clear, and that is that they want to set aside a decision that was taken by the Madibeng Municipal Council.
Yes, but if you look at the LNG decision, it's almost similar. It's a self-review, and you are entitled to all the documents in discovery. That's what that was held in the LNG matter. I don't actually have the judgment in front of me. I'll have to open it. It's on my phone. If you can just bear with me. Yeah. Do you have the copy of the judgment?
Yes, I know about the judgment, and that was a self-review, letting aside the question of whether Rule 53 applies or not.
Yeah.
That's a different inquiry. I know there's case law on that, whether section or Rule 53 of the High Court rules applies and whether you can have a record. But the LNG specifically dealt with a self-review. In other words, the SIU and that parastatal were in the same bed. They were co-applicants. Why we say that why the LNG case is not applicable is because this is not a self-review. This is the SIU standing on its own 2 feet, having a go at other respondents.
Mm-hmm.
And that is why we say that we can distinguish the matter of LNG from what is an instant case. And I hear your ladyship. So we say it's distinguishable. And also what I submitted just now is that your ladyship is functus officio. You made your ruling that they must. Yeah, you functus officio. It's all very well, with great respect for your ladyship, to have better insights now because of a colleague's judgment, good or bad, but you've made your ruling, and that is where we
and
stand.
They've not complied with that ruling.
Yes.
And they've not said why.
Yes, I don't know if your ladyship thinks that you could revisit that ruling, but we submit that.
Sure. Perhaps Mr. Tiro can, or is it Mr. Moratiwe, the surname? And he's muted. He's muted. I can see his lips moving, but he's muted.
He'll come on record.
Yes, my lady, can you hear me now?
Yeah.
My lady, with regard to the dilemma that...
Hear what he says.
Yes, with regard to the dilemma that your ladyship raises, I agree with my colleague that when that order was, the LNG judgment came after.
Yes.
You had already made an order, and that order stands up until it has been set aside.
Yes.
I agree to that extent. And I will address you based on that after my learned colleague has done that. But I agree in principle with him that you are indeed functus officio. You have made an order and it stands up until set aside. Okay.
Thank you. Mr. Williams?
Well, thank you, my lady. Now, my lady, my learned friend, I thank you for his correct and honest appraisal of that situation. That order is made. Now, the question is that my learned friend will not be able to show you that, and I thought that he was appearing also for the Madibeng, but he doesn't. He appears only for the SIU. Now, the point is that Madibeng hasn't complied with your order. They haven't given us that. The Madibeng local municipality hasn't given us anything. So that is why we get to prayer one of our notice of motion. Your ladyship's order didn't have the desired effect in getting rid of this interlocutory application because they haven't complied with your order. And that's why we apply in prayer one of the notice of motion that the court, we can't issue the subpoena. My colleague is correct about that, but that your ladyship issues a subpoena to the municipal manager and the mayor, whoever they may be, to cough it up, to bring it to court, the record to court, because there must be a record of this decision. We can't have nothing, and we're entitled to see it, to defend our tender. And that's prayer one of the notice of motion. Now, my colleague argues that a subpoena is only for trials, but we're not going under that rule that deals with We're not dealing under the rule that we're in the middle of a trial and we can issue, the parties issue subpoenas. We're asking the court in its inherent power to, we're asking the court to issue a subpoena so that we can get those documents pursuant to your order that they give it to us. And that's where we are. And if your ladyship is with me, well, then they must come on a certain date or they must have a certain time period within which to provide it. If your ladyship is with us on that.
The SIU has taken issue with the fact that the order is vague.
Yes, they say, my colleague is correct in the respect that we can't issue the subpoena. Look, in the normal case, a litigant can issue the subpoena. I just want to get to that. A litigant can subpoena witnesses. My lady, it's in your rules. It's Rule 20.
It's Rule 8.3.
It's Rule 20. Where it says there that a party desiring the attendance of someone can issue a subpoena.
Yes.
Now, we can issue a subpoena, but his point is he's saying that this relates only to trials. Well, we disagree with him there. But what we've asked is we've just asked that whether it be an application or a trial, that your ladyship calls upon the municipal manager and the mayor or the mayor to provide us with those documents.
And are they not represented in these proceedings?
Yeah, well, that's their choice. I mean, they know about the application. They've been served. And that's their choice. They're in default. They're in default.
Okay.
They're in default. So that's what the application is about. And that is what we're asking your ladyship to do.
Okay. Right. Anything else?
No, my lady. We just say that they should comply with your ladyship's order. If my learned friend takes the tack, I think there is some correspondence. I don't know if it's in the affidavit. If they take the tack, that we should bring contempt proceedings or something like that, or compel or whatever. But this prayer wasn't dealt with, so I think I can move it before your ladyship. So tell the municipal manager and the mayor to produce these documents before a certain date, and I would suggest that a month would be enough.
And if they fail for contempt?
Yes.
Okay.
Yes, failing which that they'll be held in contempt. They're not in contempt yet, but failing which that they'll be in contempt. We'll give them a month, my lady, because there are such documents, and we'd like them, as the court pleases.
But won't those documents be supplied during discovery?
Yes, my lady, but this is now rule. This is pursuant to your ladyship's order. Yeah. It's the functus officio argument again. You've given us the benefit of that order, so that's the point, my lady.
Okay, thank you, Mr. Williams. Mr. Moratiwe.
As the court is, my lady, my submissions with regard to prayer 1, with regard to the subpoena, I stand by them. I'm going to make slightly different submissions with regard to the applicability of Rule 53.
Yeah.
As I stated in the beginning, I understand that in this matter we are in the realm of Rule 53. An order has already been made to that effect.
Yeah, but you stand on your own here. Madibeng is on their own.
That is correct, my lady.
So you have no voice to speak on their behalf.
I will not speak on their behalf, my lady.
Yep.
Yes. Now, this tribunal made an order.
Yes.
Specifically,
rightly or wrongly?
No, rightly, my lady. I would submit.
Okay.
Made an order specifically directing Madibeng to file a record.
Yes.
That order has not been complied with.
Yes.
Now, my submission, my lady, is it is not open for Beto Bright in this matter to come to court and seek the order that they seek in prayer 1. It is not open for them.
Because I've already ordered.
In prayer 1, my lady, no, it is
Yes.
not.
No, because I've already ordered them to supply the record.
Yes, the order you have already ordered them to supply the record. It cannot be correct that a party would always seek a different order under the same order under a different guise, because this is essentially the same argument. We want the record, but an order has already been made. The applicant, Beto Bright, in this matter, they should have brought an application for contempt. That is their only option at this moment.
Mm-hmm.
They have failed to do so, my lady. Are they entitled to any of the relief that they seek in the notice of motion? I submit no.
May I just interrupt you for 1 minute, Mr. Moratiwe, and just proceed to Mr. Williams and ask him, why was an application for contempt not brought, Mr. Williams? That would have been the easiest way to deal with this matter, because really, in effect, what you're asking for is what I've already given you, an order for them to supply. So a subpoena is simply another way of asking them to supply those records. They've not complied with my order, so it is really they're in contempt.
Yes, my lady. If that is your prima facie view, then we would have to bring then a separate application for contempt.
In fact, that was my view before I had come across the LNG. When I first read this, that was my initial view of this matter, is that to raise this fact that you did not bring a contempt application. But it seems.
Yes, my lady, but then you must allow us to bring the contempt application. I would suggest then that your ladyship then postpone this matter sine die and reserve the costs. There are many. I don't want to drag your ladyship into a lot of cost arguments that one of your sister, but Madiba, also reserved costs in this matter. There's a lot of loose wires in this matter. So let us bring our application for contempt then, and you'll have to put us under constraints to bring such application so that the matter can proceed. We would have to bring that application for contempt, say, within 10 days or whatever. And then if we can pen this matter then and reserve the costs, that would be the quick way of dealing with this.
I don't think that's unreasonable, Mr. Moratiwe.
My lady, my submission is the applicant knew actually that they are not entitled to any of the relief that they seek. An appropriate order is that this application must be dismissed with costs. Secondly, the tribunal must then order the applicant to bring contempt application within a specific period, failing which the SIU may proceed on an unopposed basis.
Mr. Williams, I think he's right, because this is an application that has no merit as it stands. So it should be dismissed and it's not kept.
No, my lady, I disagree with respect.
I can't adjourn the proceedings. For what purpose am I adjourning it?
Well, my lady, then we'll have to hack through all the costs, because I have achieved success in this application. I got an order from you, my lady.
Yes,
so
that's for that hearing. But today's hearing.
And it was opposed. So if we are to not carry on with this application and postpone it sine die or even dismiss what we're asking today, we have been successful in getting that order, which we will base a contempt application on. And I must at least get my costs then also from the SIU until that date, and then we can talk about the costs after that.
Now, how do I do it? I have to dismiss this application because really there's no merit in it as it stands on the terms that you brought it.
Well, you can dismiss this prayer.
Yeah.
Sorry to interrupt you. You can dismiss prayer. You can dismiss prayer 1 because I can do it by way of contempt. But I have achieved the orders that we achieved before your ladyship, and the SIU opposed all of that, so they can pay our costs up to there.
That will be costs for the previous application, where I granted the order.
Yes, well, the SIU
It's
also
not this-
opposed that. The SIU also opposed that relief. So
Yes. Yes, no, I'm aware, but what date was that? Can you recall? You're entitled to
I've
that.
got your ladyship's order. I think I've got that order. It was on. I've got that order. If I can just give it to you.
Yeah.
The date of that order was 17 May 2021. 17 May 2021.
Okay.
We must get.
So did I reserve the issue of costs when I granted you that order? Or did I grant you the costs?
No, you reserve the costs at that stage, but we must get the costs up to them.
Yeah,
Against,
yes, I don't think we can argue with that.
Yes.
There can be any argument with that.
Yes.
So
And then I leave the costs after that date in your ladyship's hands.
Yeah, but today's application is aborted. Well, it's abortive. Then I have to dismiss the application with costs.
Yes, the application that's before you today. Yes.
Yeah.
But it's not the whole application. We must
I hear what you're saying.
The SIU and Madibeng Municipality must jointly and severally pay our costs up to and including 17 May 2021, including the cost of senior council. And
Okay,
then
let me just jointly and severally
the SIU and the Madibeng local municipality
pay the costs
of the application up and until including 17 May 2021.
Okay.
And if your ladyship is then inclined to dismiss what's before you today,
yes,
then we have to pay pay today's costs. Yes. As the court pleases.
Okay.
My lady, might I make submissions in that regard?
Yes, Mr. Morativi, I was going to come back to you. Yes.
My lady, the costs for the 17th of May,
Yeah.
my respectful submission is that those costs do not relate to this specific application. They relate to the main application. They relate to the main application, my lady. This application is
sorry, when you say the main application, wasn't there an interlocutory application for me to compel them? It's that application that we're talking about.
Or the application to compel, yes, my lady.
Well, and that was the order that I granted.
Yes, I will accept that.
Okay. So then my order today will read that today's application is dismissed with costs. The with costs against Berto Bright. The costs up to and including the 17th of May 2021 relating to that application shall be paid jointly and severally by the first and second.
It'll be the applicant and the first respondent, my lady.
Well, it'll be I'm just looking at my papers for today. It will be the applicant and how are they?
Well,
applicant, yes, the applicant and the first respondent. That's right.
Yes, in the main application,
in
as the
main
court
application.
As the court pleases. Thank you.
Is that clear?
That is clear, my lady.
Thank you.
Is that clear? I'll repeat that order. The today's application is dismissed with costs. The reserve costs of the 17th May, the court orders that this be paid joint up to in respect of the application of the 17th of May 2021, that the applicant and the first respondent in the main application bear these costs jointly
up to and including that date, my lord. My lady.
I'm just rewording this so that it sounds correct. Okay. And in respect of the cost of the 17th May, that the first that the applicant and the first respondent jointly and severally pay the cost of that application up to and including the 17th of May 2021.
As your ladyship pleases, my lady, one last thing. Are you putting us under? We're going to bring our contempt application. We
put you on terms. You bring it as soon as you can.
We'll do that, my lady. Thank you. Thank you, my lady.
All right, but obviously, it must. You know,
we'll bring it, my
be
lady,
as soon as possible.
We'll bring it this year still, my lady. We'll bring it. Thank you.
All right. Thank you.
As the court please.
As the court pleases, my lady.
Have a good day.